the Synergized Building, Park King Street Building, and provided to all requesting persons, organizations, news media in compliance with South Carolina Freedom of Information Act 30-4-80. Members of the public who wish to attend may do so by video. The video link is posted on the agenda. Opportunity to introduce the board members. My name is Dr. Wayne Cannon, I'm president from Columbia.
Dr. Michael Campbell from Hilton Head.
I'm Jesse Price from Charleston, public member.
Gilbert from Chapin, public member.
Dr. Brad Majors, optometrist from Mount Pleasant.
We have two members who are ill, Dr. Woods, Melissa Woods, and I entertain a motion that we excuse her absence.
I make a motion, we excuse
Dr. Campbell
Woods.
makes a motion, second.
Second.
Second. All approved, say aye.
Aye.
Any opposed, like sign. We also have a health issue with Dr. Wharton. I'll entertain a motion that we approve his absence.
Make a motion, we excuse his absence.
And we'll make a motion.
I'll second.
Second. All in favor, say aye.
Aye.
Like sign. No noes. They are both approved. We next have on the agenda the approval for the minutes from the last meeting.
I need to do the approval of the agenda, Dr. Cannon.
Need agenda first. I'm sorry, I skipped that, didn't I? I'll entertain a motion that we approve the agenda as presented.
Motion that we approve the agenda as presented.
Motion has been made by Dr. Majors. Second.
Second.
Second, Dr. Campbell. All approve, say aye.
Aye.
Any opposition, like sign. Motion carries. Agenda's approved. Now we can approve the minutes from the last meeting. Anybody have any? I have one minor change or correction. It on let's see, whatever it says here, where we have a report about from Dr. Cooper, where it says the NBEO opened a new state-of-the-art testing in Charlotte in September, which would have been impossible. That should read, will open a new state-of-the-art testing center, as opposed to opened. Make that correction. Make it correct. I don't think that needs a motion.
Yeah, I think you'd need a motion to approve with that correction.
All right, we changed it just from open to will open.
Make a motion that we make the correction as stated.
Been made. Correction?
Before we do that, motion to make the correction and approve as amended.
Make a motion, excuse me,
Moved it.
I'm sorry, is the motion to approve them with the correction as noted?
the motion is to approve as corrected.
Second.
Any discussion? Is there a second?
Second.
Major second. All in favor say aye.
Aye.
Motion carries. Okay, next thing on the agenda. We have administrative reports, the OIE report for information.
Good afternoon. Yes, I have the OIE reports, and I'm going to begin by letting you guys know that this information was collected from the beginning of the year until October the 23rd, and at that time, we have received 14 complaints. At that time, we had 3 active investigations, and we have closed 23 cases.
We'll accept that the information is for report. The next one.
The next report, we have one case that went to the IRC, and the IRC recommended a dismissal.
Anybody have any questions about the RRC report, that be accepted as presented?
I'll make a motion to accept as presented.
Motion's been made. Second?
Second.
Any,
Have to vote, sorry.
any discussion? If not, all in favor say aye.
Aye.
Any opposed? Like sign, no opposition, motion carries. ODC, anybody?
Good morning. Not good morning, good afternoon. Tina Brown with the Office of Disciplinary Counsel for the ODC report. We do currently have one case that is pending in the Office of Disciplinary Counsel that will be coming before the board. And I also wanted to take a brief moment to introduce the attorney that will be working with the board going forward. You know that we had previously Attorney Shelby Satuski. She has moved on to a different employment location, and so now we have Ms. Catherine Landis. And Ms. Landis will be working with the Optometry Board going forward.
Describe her function a little bit more in detail for us.
I'm sorry.
Is she the investigator or just a,
She's an attorney, so she'll be the attorney bringing forward any disciplinary cases that may come up with the Optometry Board.
anybody have any additional questions? Okay,
Thank you.
we have Board Executive Report. Ms. Dees?
Yes, the cash balance as of October 31st, 2025 is $401,126.25. The total number of licensees, there are 1,051 active licensees, 6 pending applications, and 2 mobile units. The list of newly licensed optometrists in your board materials are the names and license numbers of the 16 newly licensed optometrists from August 5th, 2025 to November 18th, 2025.
Anybody have any questions about the,
I have one question. One optometrist already has an OD behind their name and the rest don't. I didn't know if that meant that they transferred in from state or whether they were licensed.
That's from the online, so I'm assuming they just put in that credential, so that's why it's like that.
Thank you.
But they're all ODs.
that gets us to the, next on the agenda is the application for Dr. Stephen Thompson. He has a request to be licensed in South Carolina.
Before we get into that, I think we need to get him online. So we might need just a brief pause to get IT to get that set up so he can hear everything that's said. And just a word of note for the board members, he is going to be online on the screen. The only way that he's going to be able to hear you is if you speak into the microphone. And so these microphones move, you can pull them around. It's not picking you up unless it's red. And since he's remote, anything you say while it's not red, he will not pick you up. It's just especially important during this hearing to use the microphones.
If you just give us just a few minutes, he is not logged on. I believe he was, but then he may have gotten off, so we're trying to get him back on.
You just love electronics. I think this happened the last time we tried this.
Yeah, he selected the wrong one, so that's why he's having difficulties. But we did a test run yesterday. It was fine. So just, he should be fine in just a minute because they resent him another link. Apologize for that, but yeah. They're ready to go. He's on.
Okay, can you hear us, Doctor? Can you hear us yet? Guess not. You hear us? He's speaking. Can you hear us now? He says he can't. I'm speaking in the mic. Testing, testing, testing. You got it now? You can hear us now? We can't hear you.
Let's see. How is that?
We got you now. Can you hear us?
Better, yes.
Okay. All right, we'll call this hearing to order. This is a matter of Dr. Stephen Thompson. The purpose of this hearing is to determine whether Dr. Stephen Thompson should be granted a license by endorsement. Everyone is reminded that the proceedings are being recorded and that all witnesses must be sworn in before testifying. All remarks should be directed to me as the chair. My name is Dr. Wayne Cannon. I'm president of the South Carolina Board of Examiners on Optometry. The attorney assigned to advise me during this hearing is Dr. Eli Grote, Office of Vice Counsel with LLR. A quorum of the board is present. Do any of the board members have any reason to recuse himself or herself from this matter? Hearing none, we will proceed. This hearing will be held in accordance with the provisions of the South Carolina Administrative Procedural Act and the statutes and regulations of the South Carolina Board of Examiners in Optometry. Ms. D, is the document relevant to this applicant in our materials?
Yes.
The staff, other persons to be here today to answer any questions we might have.
No.
What questions did staff have concerning the applicant?
President and other board members, Mr. Thompson applied for licensure as an optometrist by endorsement on March 13, 2025. Upon review, it was determined that the application could not be approved at staff level due to Mr. Thompson has not completed Part 3 of the National Board of Examiners in Optometry examination.
Mr. Thompson, are you represented by counsel?
No, sir.
If not represented by counsel, you understand you have a right to be represented by counsel on your own choosing of this matter.
Yes.
Yes?
Yes.
You are electing to waive the right to represent yourself instead, correct?
Correct.
Do you have any witnesses you intend to call to testify on your behalf?
I'm sorry, could you repeat that question?
Do you have any witnesses besides yourself?
No, sir.
Okay. This time, are you ready to show us why the board should approve your applicant for licensure by endorsement despite the questions raised by the staff?
We get him
Yes.
sworn in first, please.
You can do that, ma'am. We have to swear you in, doctor.
Dr. Thompson, raise your right hand, please.
You need to raise your hand. Your right hand.
Dr. Thompson, can you hear me?
Yeah, I'm sorry, I didn't hear you.
Okay. Raise your right hand, please. Raise your right hand. There
There
you
you
go.
go.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir.
We have sworn in. Do you want to make a statement before we proceed here, doctor?
Would I like to make a statement?
Yes, sir.
Yes,
well,
you can
I-
present your
I-
case on why you believe you should be licensed. This is your opportunity to present your case.
Yes. Well, for starters, thank you. Thank you for having me today and for setting this meeting up. I guess I do have a statement here that I had written down, if I can just pull this up in a moment. So my statement is, dear members of the Optometry Board, please accept my comment regarding the board's consideration of an alternative pathway to optometry licensure via endorsement. Part 3 of the National Board of Examiners in Optometry, assessing clinical skills competency, was first administered in 1994. At that time, and for several transitional years thereafter, many jurisdictions continue to require applicants to pass their own state-level practical examinations. To my knowledge, Part 3 was not initially accepted as a substitute for those individual state exams. As new graduates during that period, we were made to understand that Part 3 functioned primarily as a preparatory or a practice exam rather than a full replacement for a state's own clinical skills test. And Part 3 does exactly what it's intended to do. While it effectively evaluates newly educated optometrists on competencies, communication, and patient safety, it does not assess the judgment, efficiency, and instinct developed through years of active patient care. Optometrists licensed before the widespread adoption of Part 3, those who had to pass all their state practical exams, have practiced at this point for decades at the highest allowed scopes and have maintained active licenses in good standing, speaking for myself, have already demonstrated the competencies that Part 3 seeks to measure. Their long-standing, safe, and effective practice reflects the same standards of patient protection that the board upholds. For these experienced practitioners, requiring Part 3 as a condition of licensure creates unnecessary cost and administrative burden without adding meaningful assurance of competency. Recognizing their proven qualifications and experience would better support public safety, professional fairness, and professional fairness. Respectfully submitted, Stephen Thompson.
Thank you. Does any of the board members have any questions they would like to address to Dr. Thompson? You're presently licensed in Minnesota and Michigan. Can you hear?
I'm sorry if there was a question. I apologize.
You're presently licensed in Minnesota and Michigan, is that correct?
Yes.
And you have passed a clinical exam with the Michigan Michigan State, right?
Yes, the clinical exam in Michigan I took in the summer of 1995.
Okay.
And it preceded my initial licensure, which was granted August of 1995.
Anybody have any questions they would like to ask Dr. Thompson?
Dr. Thompson, can you tell me your involvement with COPE and approval? Can you tell me your involvement with COPE and the approval of hours as a reviewer for COPE?
Yeah, the questions regarding COPE and my role with COPE.
Yes, sir.
Yeah, so I have been doing that since 2012. So when a conference or a lecturer or a continuing education seminar comes up, they submit their educational materials to me with how they're going to present it, in sync, synchronous, asynchronous, testing, etc. And I basically evaluate the material in the review, judge it for its clinical relevance, assign it to make sure that it's assigned in the right category for COPE, and then just make sure that the timing, that the certain number of minutes are allotted, based on how many credit hours they're doing. Take a look at the slides and just kind of review the material that way. And then I submit it as either approved or provisional or non-approved.
You ever a member of the board for either one of those states?
I'm sorry?
Were you ever a member of the board of examiners in either one of those states? Were you ever on the board?
Yeah, I'm sorry. Your microphone is cutting out. I was on the board of the Michigan Board of Optometry for 8 years, from 2004 to 2012.
Okay, anybody else have any questions they'd like to ask?
I have another question. In your correspondence with Daniel Martinez, they were looking for your Minnesota verification in your Part 3 NBEO score. We're here today because the NBEO wasn't taken. But have we received your Minnesota verification? I don't see that in the documents. Could you verify that, Patrice?
Yeah, I do have a Minnesota license, if that's what your question is. I can certainly get you that information.
We did see that. Thank you.
Yeah,
That's
absolutely.
page 46.
Okay.
This is just a question for staff, Ms. Patrice, just so the board is on the same page. Has the South Carolina optometric jurisprudence exam been taken and passed yet?
Not at this time, no.
What was the answer? Okay. Does anybody else have any questions? Do we need to go into executive session?
I'll make a motion to go into executive session for legal advice.
Before we do that, one pause. Dr. Thompson, do you have anything else you'd like to add before the board makes a decision?
No, thank you. I appreciate your time.
I have one final question. I don't see any disciplinary action taken. Can you confirm there's been no disciplinary action taken by Pennsylvania or Minnesota?
Yeah, correct. I've never had any disciplinary action taken.
I have one other question. How many current continuing education hours do you have accumulated over the last year?
How many of what kind of hours?
Continuing education, CE?
Yeah, in the past year, geez, probably 70.
Okay.
And
For a little bit of context, maybe you guys are all aware of this. I was kind of working with staff on this originally. So I hold a CELMO certificate, which is an ARBO product for some advanced level CE, kind of higher standards of CE certification. And at the time, ARBO, I guess mistakenly had South Carolina listed as accepting my CELMO certificate. So that was kind of what started this whole process back in the spring. So even though South Carolina in fact doesn't participate and ARBO had to go back and correct their website, I am a CELMO certificate holder. And so, yeah, I have a kind of a higher standard of CE count that I've had to maintain for the last couple of licensing cycles.
If there's no other questions, we'll entertain a motion that we're going to executive session.
the last question that I have, Dr. Thompson, is your plans to come here, would it be this year, next year? And because we have certain CE requirements that we have to do, you've obviously met that for this year. But as far as your plans on coming this direction, is that sooner or later or a 3-year plan?
Somewhere in between there. So we're empty nesters now for the first time, and I've got, my kids are sort of progressing through college, and so we've started taking, and I'm recently in the process of selling my practice here. So I'll be completing that sale in the next few months. So we realistically, we're probably looking at a 2 to 3 year window to maybe downsize and relocate.
Thank you.
Any further questions? Okay, I'll entertain a motion that we're going to executive session.
I'll make the motion that we go into executive session for legal advice.
All in favor, say aye.
Need a second, sorry.
Second.
All in favor, say aye.
Aye.
Opposed, like sign. Hearing none, we'll go into executive session. I guess we have to cut it. All in favor, say aye.
Aye.
Any opposed, like sign, motion carries. We are now back in session. We'll entertain a motion. We'll make it.
I'll make a motion that we accept Dr. Stephen Thompson, OD, for his experience to not have the Part 3 board, but contingent upon him passing the South Carolina jurisprudence exam.
Motion has been made. Is there a second to the motion?
Second.
Dr. Campbell, second. Any further discussion? All in favor, say aye.
Aye.
Any opposed? Unanimous consent. Motion passes. You just have to take the jurisdiction, the legislative
Absolutely, thank you.
jurisdiction part. And you have any other statement you'd like to make before we press on?
No, I appreciate all the time and consideration, and certainly I respect the process a lot. So thank you again.
Thank you for your time. Okay, we move on to the agenda. We can cut you off unless you like we'll stay for the rest of the meeting.
No, that's fine. I appreciate it. I've got some leaves I got to go rake up, I think.
Well, you ain't got as many as I got, I can tell you. Okay, thank you,
Bye, all.
Doctor.
Have a good afternoon.
Thank you.
We're going to do some kind of training. Okay, let's train.
Okay, good afternoon. My name is Jennifer Stillwell. I'm the Assistant Deputy Director for Department of Legal Services and Enforcement. I'm going to go over the investigative process. I think you all have the PowerPoint in front of you as well. So I'm going to go, if you have any questions, please ask. After me, we will have our ODC attorney come up. So I will go ahead and skip over to the page of Office of Investigations to Leadership. Of course, I've already mentioned that my name is Jennifer Stillwell. Under me is Robbie Dean, which he is actually over the business building and business board. Excuse me. April Howe is a program manager over the inspections group, and Bianca Smith is going to be over the health and medical, which is where you all fall. The way that the complaints come in, we have 4 different ways people can come in person. It can be by mail, it can be online, or it can be paper. Initial complaints. Complaints are filed by, in case if we have an inspection, a person can file a complaint with one of our inspection groups. Third parties like news articles, other agencies. Also, we have self-reports, which some boards require you to self-report. And anything arising during the course of an investigation. So if during an investigation we see that there needs to be another complaint opened, the investigator will ask that that complaint be opened up.
Define self-report.
Self-report would be like, I might get some help with my ODC attorney. You want to help? Tina, with that one?
So I would say essentially a self-report would be that individual coming forward and saying, this has happened with my practice and I am bringing it forward to the board. And so the board can do with that what you deem necessary, but I wanted to bring it to the board's attention.
So within the inspections unit, we do inspections for a few different things, and actually Optometry Mobile is one of the inspections that we do perform. We also do dental sedation, mobile and portable for dental. We do the real estate commission inspections. We have barber, cosmetology, massage, funeral that we do inspections for. So the process of opening a case, first of all, we have a complaint analyst that once the complaint is received, that person reviews it and asks, does the board have jurisdiction? If the board doesn't have jurisdiction, then we can't open the case. Then we see if the allegation, if proven, can it violate the Practice Act. If both criteria are met, then the case is open. And then the analyst will also check to see if there is a good cause. So during the investigation process, once it is assigned to an investigator, the timeline is a 30-day initiation. LLR must provide complaint and materials to the licensee for notification. This includes the complainant's name unless a good cause to withhold. Now, good cause goes through, I believe, the president, if I'm not on this board, to approve the good cause. Is that right, Eli? That's right. Okay.
Yes.
Yep. So once that's approved, we do not release the complainant's name to the respondent, which is the licensee. A licensee has to respond back to us within 14 days, and we ensure that the correct procedure is followed. So once the lead investigator gets the case from the complaint analyst, the cases are handled in the order of which they were received unless it's a high priority case. They're given a little bit more priority, of course. The length of an investigation can depend on the complexity of the issues, the number of witnesses, and the amount and types of evidence that we need to get. Also, if expert review is required. Evidence obtained during an investigation, of course, interviewing witnesses, it includes the respondent. We get subpoenas for records if we need to. We coordinate with law enforcement agencies on related criminal investigations when permitted. We do on-site visits, and we coordinate and communicate with RPP. Now, sometimes during the process, we have to do what we call an expert review process, which basically means that we have a expert that the boards get if we see it's a substandard care case, and they review over the case and give their opinion on the case. Once that is taken, then we report all this to what we call the IRC. The expert is needed if we think it's going to be a formal complaint and we need that witness, because IRC members cannot give us, cannot be a witness for our cases. The lead investigator review, so once the case is completed, the investigator will submit to the lead investigator. They review the case and make sure that it has all the necessary evidence collected and ensures documentation is in order. Then we transfer that to the IRC, which is the Investigative Review Conference. So the Investigative Review Conference is comprised of the investigator and the lead investigator, the ODC attorney, the board exec, and professional members, which is who all you requested to be on the IRC. The role of the IRC is they're conducted throughout the year. Part of the investigative process, which is a non-public body, assesses findings related to alleged Practice Act violations. Then they recommend what the recommendations are for the case, and we aim to align decisions with board handling in similar cases. So, board review of the IRC report. So, the allegation, we outlined the original complaint allegations. They may differ from the actual violations identified during the investigation. The IRC logic explains the reasoning behind the IRC's recommendations. So, this is the report that you all actually see. Key points about the report: we have no identifying information, including names of complainant or respondent, and the limited case details to prevent potential bias. So the board review of the IRC report, the board options are you can either approve the IRC recommendations, you can edit the IRC recommendations, or you can pull the case for further investigation. Are there any questions so far? Are we good? Okay, just making sure. Right. So the requirements for a formal complaint, boards follow the Administrative Procedures Act, and that governs the federal agency rulemaking and regulations. The key legal responsibilities is we uphold due process rights and follow rules of evidence and issue proper notice. Disciplinary action requirements: licensee must have violated the Practice Act. Boards act as finder of facts and trier of law, and board orders require evidentiary basis to withstand appeal. The jurisdiction and authority: professional and occupational licenses establishes board's jurisdiction. If a respondent is unlicensed, only a cease and desist can be issued. Formal complaint process: the board-approved formal complaints are transferred from OIE to ODC. So once we are done with it, it then goes to the ODC department. And that is the end of my presentation. Do you all have any questions for the investigative process? that I can help answer? Tina, come up now.
Good afternoon, everyone. And as I go through this portion of the training to talk about the Office of Disciplinary Counsel process, please feel free to ask any questions if you have any throughout the presentation. So the Office of Disciplinary Counsel, we are essentially kind of the civil prosecution arm of the agency, whereas we bring forward the disciplinary cases that come to us through the investigative process and that the board has approved to move forward with a formal complaint. In the Office of Disciplinary Counsel, you'll see who we have as our supervisors. We have myself, Tina Brown. I'm Chief Disciplinary Counsel in the office, and then we have several supervisors that are also in our office. All in all, we're slated for 15 attorneys in the Office of Disciplinary Counsel. We currently have 13. So we're hiring for 2. If you know anybody, please send them our way. We've been trying to fill those for quite some time. So that's kind of how our office is comprised. And then we also have paralegals. I believe we currently have 8 paralegals that work in our office, as well as 2 law clerks. So general ODC duties, as I mentioned at the beginning, we provide case prosecution. So if someone has been deemed to have violated a portion of your Practice Act or a portion of other applicable law, then we would bring the case before you so that you can make a determination as to whether or not this individual has in fact violated, and if this individual should receive any type of sanction for that. Legal document preparation. So we do prepare all of our documents. Those documents can consist of a formal complaint document where we're saying we're bringing this to the board. We have no agreement. We're doing a full evidentiary hearing. We also have agreements, which we'll get into a little bit further during the presentation. Case management. So we each have a caseload. Each of the attorneys in the Office of Disciplinary Counsel has a caseload. Those caseloads can vary. Typically, we'll have a variation from 60 cases to some people have over 100 cases. So it just depends on which boards that particular attorney is working with at the time. Collaboration and negotiation. So oftentimes when we present an agreement to a respondent or a licensee or to their attorney, they may say, I agree with this, but can we add this in? I was actually attempting to do this thing. Can we add this fact in? Or they may say, yes, all of this happened, but I don't think I did anything wrong. So we will kind of go back and forth to see if we are able to come to some sort of a resolution. So after the complaint approval process, for example, if there were cases to go forward today that the board approved for a formal complaint, those cases would then come down to the Office of Disciplinary Counsel, and we have various ways we can resolve that case. The first way would be a consent agreement. We have a memorandum of agreement. We have a stipulation of facts, which I'll go into a little more detail of each of those. And then for our alternative resolutions, we have a voluntary relinquishment. We have a full evidentiary hearing. We have a deactivation agreement, which is really kind of just limited to the medical board more so. But again, we'll talk about those in a little more detail. And so the differences between the agreements for a consent agreement, in some ways we kind of call it a full guilty plea, meaning that the licensee has said, yes, this happened. Yes, I agree it's a violation of law. Yes, I agree that because of that, I should be required to take courses, or I should have to pay a civil penalty, or I should have to pay the investigative cost. For the memorandum of agreement, you have an agreement that says, yes, these things happened. Yes, I agree that there's a violation of law, but we do not have an agreement as to any sanctions. So there is no agreement as to taking courses or paying a civil penalty or doing anything of that nature. The board will decide that when the case comes before the board.
Question.
Yes.
There was an individual that we asked to take some additional classes in order for him to be relinquished of what was accused against him. Does the board ever know if that has ever been, obviously that paperwork comes to you guys, not to us. Are we ever aware of those situations?
Yes, so it varies by board, and so I may turn that over
Our
to.
administrator always gives us a report back from once the whatever course they have to take or subject they have to take, that's reported at our meeting every time. By, administrator does that.
Yeah, so if a licensee is ordered to take courses, yes, they have to turn that information in to the board's administrative staff, the board executive. They will make sure to notate, yes, this person has complied with this portion. If someone fails to comply with an agreement or a board order, they can potentially be administratively suspended or have further disciplinary action take place.
Can we take action against the person that does not have a license?
We cannot. And we'll talk about this a little further, but the most that the board can do for an individual who does not have a license is
They're
issue.
practicing without a license. It says you have to have a license in our statute.
So the most we can do is issue a cease and desist order because the board does not otherwise have jurisdiction over that individual. So you can issue that.
Our statute says, well, I don't understand why not.
The only way it would have to be someone who has an active license that the board can take action on, a lapsed license, which is still a license, someone who has temporarily surrendered their license because there's still a license there. Some board statutes include that they have jurisdiction over current and former licensees. So someone who, if they ever had a license, they could be disciplined. But if they do not have a license, then the only action any of our boards can take is to issue a cease and desist.
What if they don't?
If they do not cease and desist, the first step is to issue the cease and desist order. If they don't comply and we have evidence of them failing to comply, we can take them to the administrative law court to try to get injunctive relief. And so the administrative law court can say, we'll fine you. They can order contempt where they can jail that person. They can have a number of remedies that they could potentially enact. In some cases, it may rise to the level of criminal action for someone who is basically impersonating a licensee. So that will vary. It's going to be pretty fact specific. But yes, for our purposes, the most we can do is pursue the cease and desist process.
Well, we have a situation, I might as well ask you, where our statute says that for an optometrist to practice, they have to be present. They cannot delegate without being present. And if they're doing an online exam, they're not present in person. And that licensed person may or may not have a South Carolina license. Is there anything we can do to terminate that activity like that since they're breaking the law?
The only thing we could do, again, would be the cease and desist or notify the state where that person is licensed, that we are aware that your licensee may be engaging in unlicensed practice in South Carolina, and then that board would determine what, if any, action they would take on that licensee. Okay. So in addition to resolving cases by way of agreement, we can also resolve cases. Sometimes we don't have an agreement. Sometimes we have individuals who will say, I don't agree with anything that the state is alleging that I have done, or I'm just going to make you prove it, one of the two. And so in those instances, we will bring the case forward. It's basically a full hearing where we will have, we present our evidence and our witnesses that responded or licensee has the opportunity to do the same, and then a decision is made as to what facts are believed to be true at the end, and then there's a decision. So sometimes we have to go that route, and then we have a voluntary relinquishment. every licensee has the right to relinquish their license, meaning give up their license to practice in this state permanently. So it is a permanent decision, and if someone does do that, any disciplinary cases that they may have open with our office are closed because there's no longer a license to prosecute. And so the next slide is essentially just going into a little more detail about the consent agreement. The consent agreement is typically a faster way sometimes to resolve cases if you do have a respondent who is willing to enter into that. The boards can delegate the authority to the board chair to approve a consent agreement, or the board can say, we want the consent agreement to come before the full board so that we all can vote on it. If the consent agreement is approved, that case is resolved and the case is closed, and then that particular respondent, as we talked about earlier, then has to comply with whatever the terms and conditions are of that consent agreement. The memorandum of agreement requires a hearing. A consent agreement does not require a hearing unless the board requests that. But a memorandum of agreement does require a hearing. The individual will come in, we'll put our agreement on the record. That individual can then talk to the board, provide mitigation, and say, yes, this did happen, but I was going through a rough time, or I had some personal difficulties, or something along those lines. And then the board can decide at the end what you want to do with that. You can decide that you want to, now that we've heard everything, we're going to dismiss the case after all, or we're going to issue a letter of caution, which is also non-disciplinary. But it does go in the file to say this person has been cautioned about this behavior previously. They can be issued a private reprimand, a public reprimand, on up to revocation. So the board has that full gamut of options whenever a case comes before it. The stipulation of facts is very similar to the memorandum of agreement. We agree on facts, but the respondent will say, yes, I agree, all of these things happened, but I do not agree that they constitute a violation of law. If that is the case, then we'll go through the same process of having the hearing, but in that hearing, the board will not only have to determine sanctions, if any, but you'll also have to determine if you agree with the state that there is a violation of law. And again, the panel hearings, as I stated earlier, that's basically full trial of the evidence. And so you can have, for this board, your cases, if it is an evidentiary hearing, that comes before the full board. If the board chose to do so, you can delegate those hearings because they do tend to be longer. And sometimes boards will delegate that to a panel or delegate that to a hearing officer for sake of time, because they can take hours sometimes, but that's up to each individual board to determine how you would like to handle that. But the evidentiary hearing is full evidence, witnesses, exhibits, all of those things. And so, as I stated earlier, you'll see your board dispositions of what you can do in terms of sanctions when an individual comes forward. And those can vary. I mentioned most of them. You also have the option to put someone on probation. So maybe someone has engaged in some sort of conduct like failing to supervise or failing to properly conduct an examination. That individual could maybe be put on probation, where for a year their actions have to be monitored by someone in their office, or they have to turn in reports to the board, et cetera. You also have the ability to suspend the license. Sometimes, and we'll get to this in a little bit, sometimes we have to in an emergent manner suspend someone's license. And you can also do a suspension with stay, which means that you're suspended. We're going to immediately stay that suspension, meaning that you can go on practicing as long as you take courses, as long as you pay a fine. And if you fail to do any of those things, then that suspension will go into effect. So respondents' due process. So as we're going through the process of disciplining and prosecuting these cases, the respondent is entitled to certain things. So we have to notify the respondent of the complaint allegations that are lodged against him or her. They have the right to have an attorney represent them throughout this process. They also have the right to enter into an agreement They have the right to surrender their license or to temporarily surrender their license or to permanently relinquish their license. They're allowed to see what evidence the state has. So it's a transparent process. So whatever evidence we intend to bring forward, they can see that information. They also have the right thereafter, whatever decision the board may make, they can appeal it to the administrative law court and further than that if they deem that appropriate. So other legal discipline related issues are some other things that occur. We've kind of touched on a few of them, so I won't belabor them, but just to go over them briefly. The temporary suspension order. So under the Administrative Procedures Act in South Carolina, if there is a licensee who is believed to be an immediate threat to the public, and we have sufficient probable cause to believe that this individual is a threat, we can issue an order of temporary suspension. The order of temporary suspension does not require hearing beforehand. It's basically the investigator gathers the evidence, the investigator makes an affidavit to say, this is what I have observed, this is what I have learned in my investigation. We attach any relevant documents to that affidavit, and then the Office of Disciplinary Counsel will draft an order. That order will then be sent to the board's advice council, and the advice council will then consult with the board chair to determine if we are going to issue that order of temporary suspension. Once an order of temporary suspension is issued, the licensee does have the right to challenge it. So the licensee can say, I don't think this is appropriate. I am not a threat to the public. I would like to have a hearing. And if that is the case, then we will schedule a hearing and determine if that order will be upheld or not. Typically, those hearings are overseen by a hearing officer that is approved by the board. Sometimes that may be one of the board members. Sometimes we've had IRC members do that function, but that would be a determination by the board. The next we have is orders requiring evaluation. I wanted to keep this in the slide because we do issue these orders routinely. However, in order to issue an order requiring evaluation, that board's Practice Act has to have language that allows it. So currently, the Optometry Practice Act doesn't allow for us to pursue an order requiring evaluation. We can pursue an order of temporary suspension because that is included in the Administrative Procedures Act, which covers all of the boards. But if we do have an individual that maybe there's accusations of impaired practice due to alcohol, drugs, et cetera, we wouldn't be able to order them to go get evaluated. We would have to move forward to suspension. We can ask the person to be evaluated, and if they voluntarily go, then we're fine. But otherwise, we would have to immediately go to suspension. So the order requiring evaluation is just kind of another level where we're being a little more cautious because we're not really wanting to take someone out of practice if we don't have to. But again, it has to be allowed in the Practice Act for each board. So the cease and desist orders, which we were kind of talking about earlier, this would be for individuals who do not have a license, but they are engaging in actions that under your Practice Act would constitute the practice of optometry. And so if that is the case for those individuals, we can issue the cease and desist. They work similar to the order of temporary suspension, where the investigator gathers information, they consult with the attorney in the Office of Disciplinary Counsel, we package all of that together, we do a proposed order, and then we send it to the advice council. Advice council consults with the board chair to determine if we are going to go forward with issuing that order. If someone fails to comply with the cease and desist order, we can, if we have the requisite evidence, we can take them to the administrative law court, ask the administrative law court for injunctive relief of some sort, and we can pursue it further if they continue, and if we have that evidence to support it. Agreement to voluntarily surrender is temporary. It's where maybe a licensee is engaged in impaired practice, which is where we most often see it. And that licensee is saying, yes, right now I'm struggling, I am dealing with an addiction, I agree that I am not safe to practice. I am not in a position to practice right now. So they will temporarily surrender their license to practice. In order to get that license reinstated, typically they will have to come in front of the board to request reinstatement. In some instances, if they go in and get evaluated and the evaluator says you're safe to practice, we may do an interim order, which is drafted by the Office of Disciplinary Counsel, and present that for the chair. In those cases, they may not have to come for a hearing, but typically they'll have to come for a hearing. The voluntary relinquishment, again, I mentioned this earlier, this is permanent, no more practice in South Carolina. And of course, if someone relinquishes a license in South Carolina, if they're licensed in other states, that could negatively impact those licenses. Or if they try to get licensed in another state and they've relinquished here, because relinquishment, the language in our relinquishment agreements typically will say it was done in lieu of, in the process of an investigation where if the facts were proven to be true, they would have violated their practice act here in South Carolina. So it can negatively impact other states as well. The Recovering Professional Program, so this is RPP, which basically if there is a licensee who has impaired practice, we can refer them to RPP where they'll go through an intake process. They can complete an evaluation to determine, they'll take toxicology screening so we can just kind of get a picture of where this person is. And so it may be related to substance abuse. It may also be related to mental health. So it can be both reasons, or sometimes it is both reasons. Sometimes it's one or the other. They'll go through this process. The board gets that evaluation back and then can determine how to proceed with that licensee. If it's someone who has been deemed to have a substance use disorder, they're recommended for monitoring, then they will monitor with RPP from anywhere to 2 to 5 years. If they have non-compliance issues with RPP, that 5 years can be extended. So they can reset their time essentially. But anyone participating with RPP, they are randomly drug tested. They're drug tested anywhere up to 26 times per year, unless they transition to senior monitoring where they're typically drug tested 13 times a year. Again, it's random. They have to check in every day. When they check in, it's a program called Recovery Track. When they check in, they will be notified if today is a drug testing day for them. So they will have hair follicle tests on occasions, they'll have urine drug screens, and then they will also have alcohol testing, which is called PEth testing, which tests for a period of time. So they will have those tests, and RPP will regularly update the board or notify the board if that licensee has a positive screen or otherwise becomes non-compliant.
Question, you had mentioned that we don't have the orders requiring evaluation in our Practice Act, I guess, but do we have the other 5 that you're talking about here, or?
Yes.
You?
Yes. You have all the others available to you. Now, when I say the order requiring evaluation, meaning that when it's on our end of things, meaning they have not been determined by the board to have engaged in misconduct, they haven't been determined to have violated statute yet, we can't, as a preliminary matter, without a hearing, issue the order requiring evaluation without the statutory authority. But if someone comes to the board and during your board hearing, you're listening to them, we have presented evidence that they may have impaired practice, you can then order as a remedy at that hearing that they get evaluated. So it's just not something we can kind of do on the front end as an emergency issue, but it is a remedy the board can do on the back end once you have adjudicated that they have in fact violated their statute. And the next slide is just a picture of a few of our ODC people. So that's all that I have. Are there any questions or concerns for me? Thank you so much.
I think it's my turn.
Got more training?
We've got more training, but I will try to keep it brief and we'll press on. All right. So there's a little bit of information about OAC in the slides that you have too. I'll cover a little bit of that, and I'll go a little bit outside of that as well. But Those who have served on the board probably have some familiarity with the Office of Advice Counsel does, but we also have a new board member, and so there may be some information that we can provide here for you too. So, as can be seen today, one of the functions that the Office of Advice Counsel does is they provide legal advice during the meetings, whether that be operating the meeting, providing, answering legal questions and things like that. We're here attending the meetings to provide the legal assistance that you need during the meetings. But outside of meetings, we do work with staff. So if there are application questions that come in, things like that, we assist and help provide legal advice to the board's staffs as well as the agency as a whole. Part of what we do is to make sure that the operations comply with the law. Applications are coming in, they're being processed in accordance with the law, that the board is operating in accordance with the law, and that's one of the tasks that the Office of Advice Counsel handles. There are orders that need to be drafted as a result of a hearing. Advice Counsel does those. If those orders get appealed, someone in the Office of Advice Counsel, if it's a non-disciplinary matter, would handle that appeal. If it's an appeal from a disciplinary case, it's for somebody from the Office of Disciplinary Counsel that would handle the appeal on that. And in addition to the services we provide to the board, we also provide, like I said, intra-agency support amongst the personnel here. We're also involved with, keeping up to date with legislation. We have a governmental office. We coordinate with them to make sure that the board can get up-to-date information about bills and statutes that may be coming down the pipeline to affect the board, and helping provide guidance and assistance on existing and proposed legislation that may come about. Since I've been with the board, we haven't gone through the regulation drafting process for this board, but we have with other boards. So if the board were to adopt regulations or want to propose regulations, then Advice Counsel would help in drafting those and going through that process. In a nutshell, the Office of Advice Counsel just provides general legal support for the board and its operations. So, outside of the general role of Advice Counsel, I did want to talk a little bit about just some of the framework of the boards in general and the Optometry Board. And so I think one thing that I tell boards, and I think it's important for all boards to keep in mind, is, what is the purpose of the boards in general? And there's something we call the Engine Act, which is Title 40, Chapter 1. There's a provision in there that says that the right of a person to engage in a lawful profession, trade, or occupation of choice is clearly protected by both the Constitution of the United States and the Constitution of the State of South Carolina. The state cannot abridge this right except as a reasonable exercise of its police powers when it is clearly found that abridgment is necessary for the preservation of the health, safety, and welfare of the public. And I think that's just an important statement to keep in mind as you do your board functions, that it's one of the overlying purposes of a licensing board is the preservation of the health, safety, and welfare of the public, and the actions of boards should be guided by that principle. Some of the rules, laws, regulations that are relevant to this board are some of the following. It's not intended to list everything, but you have the South Carolina Constitution. You've got Title 40, Chapter 1, which is commonly referred to as the Engine Act. That provides overarching provisions to a multitude of boards in South Carolina. Your board's Practice Act, which of course is Title 40, Chapter 37. There's also the Eye Care Consumer Protection Law, which is Title 40, Chapter 24, that has some provisions pertaining to optometrists, and your board's regulations are found at Chapter 95. Some of the other less obvious ones to you may be the Freedom of Information Act. A lot of people think of the Freedom of Information Act in the context of a governmental entity producing documents, but it also applies to open meetings, and we'll talk to that in a little bit. The Administrative Procedures Act, we'll talk a little bit as well, but that provides a framework for essentially administrative hearings and due process in those hearings. And then, of course, the State Ethics Act, which you all most likely have some familiarity with and that you're subject to. So some of the board responsibilities can be found in the Engine Act and in the Practice Act. 40-1-70 and 40-37-40 are a couple of those. So some of the specific powers and duties of this board include the following. Again, this is not an exhaustive list, but determining the eligibility of applicants for examination and licensure, which may include holding application hearings, which today was an example of that. Prescribing subjects, character, and manner of licensing exams, establishing criteria for issuing and renewing licenses, adopting a code of professional ethics, conducting disciplinary hearings and disciplining licensees, promulgating regulations, evaluating and setting criteria for continuing education hours and programs. And it's just important as an overarching principle that the board stay within the authority provided to it by its governing laws, and that's part of the role that I'm here to help you with as well. As far the Freedom of Information Act, most of you probably have heard it referred to as FOIA. It governs both public records and public meetings. Since what we deal with primarily is you as a board or the meetings, I'll focus on that. Meetings are generally required to be public after proper notice has been given. The agenda has to be posted no later than 24 hours prior to the meeting. Therefore, because of that, the board should not be meeting in private, conducting meetings with outside of that framework, because that would be problematic under FOIA. Just keep that in mind. In certain circumstances, a meeting, or at least a portion of a meeting, may be closed to the public. There are exceptions to FOIA. One of those exceptions that we frequently deal with is to receive legal advice. But there may be some things outside the FOIA exceptions that come up in meetings if there's some sensitive or confidential information under another law that protects privacy and confidentiality, such as maybe some very sensitive medical information that would have to come out in a hearing. In certain circumstances, then those portions of the hearing can potentially be closed. As far as hearings, the most common hearings that you as a board will likely see are application hearings and disciplinary hearings. Those are by far the most common. But there's a few things just to keep in mind with respect to hearings, and this is just a broad, overarching, some things to consider. We're not going to go into all the fine details of everything, but the South Carolina Constitution and the Administrative Procedures Act provide for due process and procedural protections. I think that was discussed a little bit previously. But in a nutshell, these protections include providing proper notice, an opportunity to respond and to present evidence and to cross-examine witnesses. And so just keep in mind that when hearings are taking place, that the individuals that appear before you are entitled to that due process and to keep those rights in mind as conducted. Without going into all the specific provisions, keep in mind that there are provisions that require the board to be impartial, and you can't serve as both a prosecutor and an adjudicator. So you can't bring a case against somebody and then participate in the case and try to prosecute it and also serve as the adjudicator. That's problematic. So just keep that in mind. Board members need to be fair and impartial and not be subject to bias or be tainted by outside knowledge. If you do have some of those issues arise, certainly consult with me and we can discuss in private whether you may need to recuse on that matter, and I can provide. Outside or prior knowledge of facts or of witnesses or any direct connection to the facts or persons involved in a connected case, again, can issue that you may need to recuse from. And so when you're hearing cases and evaluating whether it's something you can participate in, be aware of your personal bias or prejudice concerning a party, whether you have any knowledge of disputed evidentiary facts concerning a proceeding. Did you have any personal interest in the outcome? Have you made a prejudgment against someone? Do you have any other conflict of interest? Is there a financial connection to the case? Would you benefit financially? please keep all those in mind so you can avoid any conflicts of interest. When it comes to hearings, there'll be evidence presented. You need to confine your findings and conclusions to the evidence that's presented at the hearing, as opposed to doing independent research or trying to find things outside of the hearing. Ex parte communications are not allowed by law, so basically, to distill it down in a nutshell, if you're going to be hearing a case, you should not be communicating directly with an applicant or a respondent or a witness and then participate in the case, and especially outside. So, for example, in disciplinary cases, there'll be the state have an attorney and there'll be the respondent. You shouldn't be communicating with one or the other outside of them, and of course, you shouldn't be communicating with them directly at all. That should occur at the board meeting to avoid any sort of ex parte communications and outside communications on the case. So once the final order is issued, if a party's aggrieved by a final order, they would have 30 days to appeal that written order to the Administrative Law Court. Just briefly, the State Ethics Act, we've mentioned that previously. The board members are subject to the State Ethics Act. Certainly be careful that there's provisions in there that deal with financial conflicts of interest and other conflicts of interest. And of course, you'll have to fill out your statement of economic interests. I don't think this would apply. Obviously, it wouldn't be on the board, but there's a provision of the law that prohibits lobbyists from serving on the board. So if you were to become a lobbyist, that would be problematic and you wouldn't be able to serve on the board. Removal of board members. The governor does have the authority by statute to remove persons from boards. Some of the things that the governor can remove board members for are malfeasance, misfeasance, incompetency, absenteeism, conflicts of interest, neglect of duty in office, incapacity. Those are just things to keep in mind. And just on a concluding note, keep in mind confidentiality. The board, you as a board member will be exposed to information that's personal in nature or may otherwise be sensitive. So the board materials that you're provided access to should be kept confidential and not shared with other people. If somebody wishes to obtain records from the agency, they can submit a FOIA request. The board should not be distributing materials to. I'll leave it at that. I know we're close to 4:30, and I know the board wants to keep moving.
Okay, next on the agenda, anybody have any questions? Thank you for that. Anyway, the next on the agenda, we have old business, which is the window tint issue. Our legal advisor over here has some information about that.
I'll start off. If you'll recall from the last board meeting, there was a question presented. There was an old memorandum from 2007, and it was brought back before the board because there were some questions about whether apparently it had been distributed, and so it was brought back before the board for them to reevaluate it. And I understood from the board the last meeting that the recommendation was to take a look at that and potentially update it and potentially send something out. And so I've done a little bit of work on that. But it has also been brought to my attention, and it's in your board materials, that there's a bill that has been introduced that addresses the window tint. It's Bill H 3151, and that's also in your materials. I've gone through and looked at the old memorandum, and I've provided a draft of some revisions, but I did want to have the opportunity to provide you a little legal advice about that, if someone would be willing to motion to receive a little bit of legal advice about this topic.
I make a motion that we accept further legal advice on this topic.
We have to go into executive session for that? Not really, wouldn't we?
Yes.
I'll second the executive session to receive legal advice.
There's a second.
Second.
It's already seconded. That's it. All in favor, say aye.
Aye.
Motion carries. Anybody opposed? Motion carries. We'll have a quick legal advice. We have a motion on the table to table the winter tent issue for the time being.
As there is a current bill regarding window tint, I'd make a motion we table this until that decision's made.
Motion's been made. Is there a second?
Second.
Made and seconded. Any discussion on the motion? All in favor say aye.
Aye.
Motion carries. Okay. We have, the item 11 is the approval for the Arbo Conference in Phoenix. We normally send 2 members and a director. I'd like to make a motion that we approve this.
I'll motion that we approve 2 members and an administrator for the Arizona conference.
Second.
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 Discussion, all in favor say aye.
Aye.
Any opposed, like sign.
Dr. Cannon, do we know who the 2 board members that will be attending?
We can, well, I'll be one, and whoever else wants to go volunteer. We can, you want to go back to Phoenix?
What are the dates?
Yeah, June 13th, 14th. We can figure that out. If somebody else wants to go, because two of the members aren't here, maybe one of them want to go. Okay, we got the SCOPA meeting, which is in Hilton Head, August 22nd. Make a motion that we send the president and vice president.
I'll motion that we send the president and vice president.
Is there a second? All in favor say aye.
Aye.
All opposed, like sign. Motion carries. The only other thing we got on this certificate for vision examination, I would like to say that Dr. Woods and I visited the examining station in the new facility in Charlotte on the 13th of this month and had a very good visit. She was going to give a report, but since she's not here, we'll let her give it at our next meeting. I can give you a quick update, but the facility is second to none in Charlotte. It has double the space that they had, better location, and the facility now can accommodate twice as candidates as they had in the past. And it's, I say, considered the highest level and fully reflects trust that the members of that organization are competent to successfully complete 3 parts of the exam, as well as the rest of it will meet the established standards for our profession as we go into the future.
Just for clarification on this specific item, the certificates of vision examination, Dr. Kane, I think this is something you requested be on the agenda just for a discussion purpose. It related to the certificates of vision examination for people to get their driver's licenses. I think it was noted that there had been a change that certificates of vision examination are valid for 36 months from the date of exam now. That was a change. The statute, which was South Carolina Code Section 56-1-220A, was amended in May of 2024, and it changed the certificate validity date, or the period, from 36 months to 12 months. I think that's what that was about, and whether you wanted to have a discussion on that or not. Or at least put it out there to the board for general information.
Well, we'll accept it as information, how much we can do about it.
I don't think it's not a board statute, it's a DMV requirement.
Right.
I think it was just something that you had requested be on the agenda to maybe note for the board members.
Anybody have any questions about that? If not, I think that concludes our meeting. Will be January 28th, the next scheduled meeting. And is there any public comments? I don't see any public out there. If not, we will adjourn. I'll entertain a motion that we adjourn the meeting at 4:40.
Make a motion that we adjourn.
Second.
Second.
All in favor, say aye.
Aye.
We are adjourned.